Welcome back to another episode of Grizzly True Crime. My name is Gabriella K, and in this video, this is a condensed version of a live stream that I did. I will link that live stream in the description box for you if you do want to hear my commentary on what happened on August 23rd, 2023. There was a scheduling conference held for Bryan Kohberger that his defense team requested, and there was a lot of speculation online of what that could mean. Most of that speculation was right. Bryan Kohberger waived his right to a speedy trial, which in layman's terms means he's not ready for a speedy trial. Okay, he doesn't want it, waiving his right to it, and therefore they need more time to prepare everything for the trial, which means the October 2nd date is no longer valid. The trial will not start on October 2nd of 2023 as planned. It was going to happen from October 2nd to November 17th. And they already said when jury selection will be, which was just the week before. That is no longer happening. So what is happening is a hearing on September 1st. But all those other dates, all those other deadlines, that's all going to be shifted. So you might as well Control-Alt-Delete that from your mind. So if you watch those episodes, that's how it was just a few days ago. That's what they decided. Well, that's all gone now. And it's almost like, it's not quite a clean slate because, of course, those things will still happen just at a later date and at a much slower pace because this is a death penalty trial and both the prosecution and the defense, they have a lot to prepare. It's interesting that the defense are the ones, of course, that are like, whoa, time out, which Kohberger said he's fine with. Now, the thing is, why does it matter if he's fine with it? Right? He's a suspect, number one. He's innocent or proven guilty, right? And so he has the right to a fair trial. And what would the negative side of this be for him? Why would the judge say, are you sure you're okay with this? Because that means he's going to have to sit tight in jail for as long as it takes, which he said he's okay with. This could be 6 months, a year, 2 years, 3 years, 5 years, more. We just never know how long this could actually take. So he's going to have to sit tight, be in jail, and wait for all these legal proceedings to take place. There'll be lots of hearings, lots of things, but hopefully, on September 1st, even though if this happens, they can still change the date. Hopefully, the goal, from what they said, is to set a new trial date then. So we shall see. Let's see. What will they set it as? Comment below when you think that'll be. So we'll keep our eyes peeled for that. Also, his attorneys have filed a motion. They said they're going to file a motion. As soon as we have that, if it's interesting to bring to you, I will read it through with you. But the thing is, they don't want cameras in the courtroom. Now, that's going to be interesting. Whenever the trial will be, oh man, then it could be like Lori Vallow-Daybell's trial, where we get audio only, no matter what it is. Here at Grizzly True Crime, we are following this case very closely. So if you do want to follow along, if you've missed out already, if you're only joining now, like, oh, wow, she's covering the case. Yes, we've done a deep dive from day one, okay? So check out the playlist. There's content on there that you might still be really interested in replaying, in watching. A lot of the information is not old information. You can still look at it and check it all out, right? So the playlist is linked for you as well. Make sure you subscribe, hit the bell, okay, so that you don't miss out on any other updates. There's still going to be lots of shifts and changes and things, as we know, as we learn from other cases. I'll keep you posted on all of them. So make sure that you watch the videos, that you check in for the live streams, that you check out my YouTube shorts, because sometimes if it's just like a quick update, I'll update you there, or the community tab as well. You can check that out too. So when this breaking news came out, that's where I updated you first, because it was just past midnight my time, and that was the best I could do at the time with, whoa, breaking news. So they're saying this and this, and I also was waiting for more information, and of course, the footage from the scheduling conference, which is what I'm going to play for you now. Now, what I've done is I made sure to put the date of when it happened. I've made sure to put key phrases as it happens on the screen. So if you are watching and not just listening while you're busy doing something else, right? Make sure that you're reading those things so that you understand what's happening as it goes on. Thank you so much, and I will see you in the next one. Stay safe.
Taylor requests a status conference for today, so here we are. Go ahead.
Thank you, Your Honor. Your Honor, we asked for this status conference today because I have had some opportunity to meet with Mr. Kohberger and talk about his trial date and his speedy trial right. Your Honor, we're here today to ask the court to continue the trial setting, and Mr. Kohberger is prepared to waive his right to a speedy trial. Your Honor, there are a couple of things that I need to place on the record. One can come after the court takes his waiver, but one I think ought to come before the court takes his waiver. Your Honor, as the court knows, we will file a number of motions to strike the death penalty and Idaho's scheme of capital punishment. Because we're here today to waive speedy and ask the court to continue, I think the court and counsel ought to know that one of the motions that we will be filing is a motion to strike the death penalty because it places Mr. Kohberger in a position where he has to choose between two rights. One, that being the right of the speedy trial, or the other right to effective assistance of counsel. I didn't want that to come filed later and have it be any surprise that I knew it was coming. It will be coming. That motion will be coming. And for us to stand up and request a continuance and waive speedy today. The rest can be placed on the record after the court's questions. Mr.
Thank you, Taylor. Well, you heard all that, Mr. Kohberger. Yes?
Yes.
And is that the case that you want to waive your speedy trial rights?
Yes.
And you understand that those rights are statutory in Idaho, also protected by the United States Constitution and the Idaho Constitution?
Yes.
You understand that if you waive, you're waiving really forever in this case. So if we were to push this out, this case, and then something else happens that allows us or requires us to push it out a little farther, you can't claim your right to a speedy trial at that point. You understand that?
Yes.
So have you had enough time to discuss this with Ms. Taylor?
I have.
Is anybody pressuring you to waive your speedy trial rights?
No.
Okay. You sure you want to do this?
Absolutely.
Okay. You agree with this, Ms. Taylor?
Your Honor, I do agree with this. I do not believe counsel can be effective by October 2nd, the entire phase, if we should end up in a part 2 of this trial. Our investigation is not complete. Our work with experts is not complete. We haven't completed our review of the state's evidence. I do not believe that we can be effective by October 2nd.
Thank you. Is Mr. Kohberger willing today to write, sign his name and you to sign your name on a waiver of speedy trial?
Your Honor, I can tell you that I did not prepare Mr. Kohberger for that, and that would be because I am not familiar with this court's practice. I expected we would waive in open court today, and that would be sufficient. I'm happy to take a look at what the court wants us to look at.
Well, I wasn't really anticipating this, but just in case, and hypothetically, I grabbed a Odyssey form, which I don't really favor those forms, but I did pull that out, and maybe I could give this to you and Mr. Kohberger, and we could take a look at it. My practice is always to get a written signature of waiver in any waiver of speedy trial. So let me go to, and I haven't taken his waiver yet. I'm going to notice that, but just want to let that settle for a second. Mr. Thompson, do you have any objections?
No, Your Honor. I mean, I think everybody would like to have it resolved sooner than later, but I think the case is of such great importance and complexity that this is a smart move.
Thank you. I do agree with that. I mean, we have so many things going on. There's a lot of issues left to resolve. And as you know, I mean, you probably could understand that. And you were all thinking this, that it's going to be very difficult to put everything together that needs to be put together before October 2nd. This is a very significant, complicated case for all the lawyers, and particularly for Mr. Kohberger. So I understand you want to be fully prepared for the trial, and if it happens, also so. And likewise for the state, likewise for the court. I mean, I was willing to do that, but you don't want to be nothing. I mean, any of these issues, because they're all important. So, I don't know, could you take a look at that form?
Maybe we have just a moment.
Yeah, go ahead. So, Mr. Kohberger, did you read this over?
Yes.
Okay, what I'm talking about is the written waiver of speedy trial.
Yes.
Did you understand the terms here,
Yes.
which we've already talked about?
Yes.
And you agree with the signing of the form waiver of speedy trial, Ms. Taylor?
I do not.
Okay, so Mr. Kohberger, do you want me to accept your waiver?
Yes, I do.
Okay, and you understand that if I accept your waiver, you're giving up your constitutional right under the United States Constitution and the Idaho Constitution on a constitutional right of speedy trial?
I understand.
Do you understand that if I accept your waiver, you're also giving up your Idaho statutory right to a speedy trial?
Yes.
That is within 6 months of your arraignment.
Yes.
And you agree with the tender of the waiver, Ms. Taylor?
I do not.
Kohberger, do you want me to accept your waiver?
I do.
Based on our discussion, your waiver of these rights expressly in court and also in signing this waiver of speedy trial. Also, you are tendering these waivers on advice of counsel. I will accept your waiver of speedy trial. I find that your waivers are knowing, intelligent, voluntary, and there's actually good cause to recognize that. Given what I heard from your counsel, Mr. Thompson, and my clients as well. So, with that, we can talk about resetting this. I'm prepared to do that today. Sarah?
Your Honor, I would say that we are not prepared to choose the trial date today. That brings me to kind of the second part of what I wanted to talk to the court and counsel about today. We currently have September 1st as the date for the motion to dismiss the grand jury indictment. Our deadline to file our challenges will be today, and we're prepared to file those today. Our hope is that that particular hearing date, we'd like to keep it, both challenge the grand jury indictment, and also there are 2 additional motions that we're going to be filing, and we're hoping that we can have those heard. After that time, after we've heard the motions, we'd be in a position to meet with the state if they desire and talk about a reasonable trial setting. My preference would be to have us discuss that and reset the trial one time and not do this a number of times and worry about getting subpoenas out and worry about calling. That would be my request. The other deadlines that are in place right now on the court's scheduling order, I think those would be appropriate for us to talk about the state and the defense and perhaps suggest for the court to order a different scheduling order than the one that exists. We just simply want to keep the grand jury indictment challenge date because that's soon, and having the court's decision on that will largely impact what comes next. If the court will allow, I'd like to briefly address the other 2 motions that are coming and have not been filed today.
Sure.
Okay. Your Honor, we will be filing a motion that has to do with media in the courtroom, particularly for cameras in the courtroom. And that motion should be filed by the end of the day or first thing tomorrow. That comes from some things that happened last week when we were. The other motion, Your Honor, has to do with what happens to witnesses that the defense might call. The court will recall Gabriella Vargas testified last Friday in our hearing. Last night, she was visited by 2 FBI agents and interrogated about her testimony at the timing of her declaration. That, in our view, impacts Mr. Kohberger's due process rights and his rights to effective assistance of counsel, and that motion will also be filed later today or first thing tomorrow.
Any objection to hearing this here, the motion along with these 2 more motions to be heard on September 1, Mr. Thompson?
I don't believe so, Your Honor, having not seen exactly what the motions are, but understanding they're fairly straightforward. I would think that we could, if we look at the motions and we have an issue with raise the court to Ms. Taylor. I will, for the record, since Ms. Taylor has brought up the situation, Ms. Vargas did court and counsel background. Over the weekend, Ms. Vargas, after she testified, engaged in some electronic communications with others in the genetic genealogy field. Those indicated, as it was reported to the investigators, to our investigators, that she was rebating on some of the things that she testified to in court. When we heard of that, I reached out to the investigators and said, can we find out what's going on? And the FBI indeed undertook an investigation. And preliminary reports are that Ms. Vargas claims that some of what was in her declaration, she inadvertently agreed to or signed without fully reading it. We're documenting that so we can expose it to Ms. Taylor and to the court, because I think it goes directly to what happened last week. That's the only reason that she was contacted, because it was reported to us that she was retracting some of what she had testified to and what was in her declaration. And we felt in fairness we need to uncover that quickly. There was no other motive, no other motivation for this. I just wanted to thank the court.
Your Honor, that's certainly different than the information that I received. I would have been happy to be advised about that, but I'm not sure that's accurate. I mean, I'm sure that's what Mr. Thompson heard. I'm not standing here calling him a liar, but the quality of the information he's received, I'm not sure that's entirely accurate. My hope is that these 2 FBI agents that were at Ms. Vargas' home last night, hopefully they reported everything that they talked to her about, and that should resolve the issue of last night.
Okay, great. hear about it at the hearing. That's how we sort these things out.
Here.
So, back to a change of the scheduling process, or scheduling order. I mean, I think it does make some sense to redo that. You want to just talk about that before we start taking that apart? We don't have to do it right now, so.
Judge, the state's position would be is that the court vacate the October trial date, vacate the scheduling order, let us get through what we're going to do on the 1st, and then let's talk and see if we can come to an agreement. If not, allow the court to set a date for a trial that's realistic, and then have a scheduling order generated that reflects the time preparing for trial and is useful for both parties to do what they need to do.
Is that acceptable, Ms. Taylor?
Yes, Your Honor, I agree. We should get through the hearing on the 1st, and then we're happy to meet with Mr. Thompson in his office and discuss an appropriate trial date.
That counsel can talk about some of those things before taking it back to the court.
Yes.
I am fully supportive of that. So I'm vacating the trial, October 2nd, and I'm vacating the scheduling order except for September 1st. Okay? So accepted Mr. Kohberger's waivers, speedy trial. I have maybe a personal issue to discuss with you. First of all, I wanted to tell you I'm getting requests for excuses already from potential jurors, and what I'm doing is not excusing anybody at this point. I'm the commissioner. Jury commissioner is just collecting those, and then we're going to do those excuses on the record with you. Okay, I think that's appropriate in a case like this. Does that make sense, Ms. Taylor?
The excuses are from potential jurors who are not needed.
They may be needed. I mean, these are expanding the panel. Okay, because I was thinking that I need a lot more potential jurors to show up. Objection to me excusing myself. I never thought I'd actually face that. But, I mean, I don't think I could be a juror in this case.
I would agree, Your Honor, that the image of the court going from the jury box, that is just...
It's entertaining.
It is, but I understand and I would have no objection to support it.
Thank you. I thought about that, like going back and forth. I might get tired. But, Mr. Thompson?
It makes perfect sense for the court to excuse itself.
It's odd, but it is logical. But I felt kind of awkward thinking that I would do that, talk to everybody around me.
We would not want to confuse with pardoning yourself, though.
Right, of course. Always with an open mind.
Yes, sir.
All right. Anything else we need to address today? Ms. Taylor?
No, Your Honor.
Mr. Thompson?
No, sir.
All right. Well, thank you all, and have a good rest of your week. We're adjourned.